the Softgel Healthcare Private Limited versus.
I think this is a very important development to the extent that
which include Ayurveda, yoga, and
the divide between patent law and competition.
This episode, we'll be talking about the important patents development. We'll first start with decisions which were topically relevant, which were in the news. So first we have Bharatwaj.
Yes, so I'll be discussing communication components antenna versus ACE technology. So the reason this specific case came up in the news is because of the interim deposit that was provided, relief that was provided by the court. It was around 290 crores. To give a comparison, in a previous case involving the same plaintiff, the court had granted damages to amounting to around 217 crores. Now, how did the court come up with this 290 crore amount? The court considered 25% of the damages that the plaintiff had initially sought, which was around 1,160 crores. And 25% was granted on this. Now, why did they grant so large an amount? And the major reason that was cited in the judgment was the fact that the defendant in this case was a South Korean company who do not have any assets here in India, which kind of made it difficult, at least from the point of the plaintiffs, to enforce any decree that they get in their favor. And the plaintiff in a previous case that I had mentioned was not able to, at least to the extent their lawyer admitted before the court, that they were not able to enforce their own previous decree of 217 crores against the Chinese defendant who had shut shop and left to China, and now you can't do anything about it. So in that light, I think the reason I think it caught the news cycle is because also it kind of enables to project that India is a enforcement friendly country. We are willing to grant this much interim deposit relief because, as listeners would know, any kind of interim relief is done before the rights and liabilities of the parties are decided. So in a sense, the court is deciding the entire issue on a prima facie basis where the situation can change after trial. So in that case, I think this is an important development, meaning an eye-catching development. I'll just pass it on to Prahash now.
Thanks, Bharatwaj. Now we have Ambika, who will be talking about another important decision.
Thanks, Prahash. So in Novenco versus Xero, the Supreme Court has given a landmark judgment which has implications on the availability of alternate dispute resolution mechanism for IP disputes. Section 12A of the Commercial Courts Act mandates pre-institution mediation for commercial suits unless there is a need for urgent interim relief. In this case, the key takeaway is that the Supreme Court has said that for IP disputes, this urgency is inherent in the dispute because of the fact of a continuing infringement, which the court believes also has a harm for the public interest and it creates consumer confusion. So if as a plaintiff, you have a certain delay in instituting your IP infringement suit, the court will not consider this as negating the urgency of your appeal. The effect is that this will alter litigation strategies going forward now that IP disputes are not mandated to have mediation proceedings. It still remains to see whether parties will use mediation as an alternate choice by themselves. But the bigger question this raises is the way the court considers IP. So it has basically clubbed every different kind of IP as the same thing, as the same subject matter. And we must question if every IP infringement harms public interest or does every IP infringement create consumer confusion, because sometimes that's not really what happens. Yogesh has an excellent post about this on SpicyIP where he discusses all of this and gives some pointed criticisms for the judgment. I definitely recommend checking that out. And now on what does the court think about Ozempic, we have Karthikeya to discuss.
Thank you, Ambika. So India's courts just sent a massive shockwave through the generic industry in the high-stakes case of Novo Nordisk versus Dr. Reddy's. At the center is semaglutide, the world's famous blockbuster compound behind the weight loss drug that we all know at this point. Preliminary finding, the Delhi High Court agreed that Novo Nordisk's patent was likely invalid. The court noted that it appeared to be a case of evergreening, essentially trying to extend a monopoly through minor modifications of an older expired genus patent. But here's the paradox. Despite the patent being weak, the court still blocked Reddys from selling its generic version in India until the patent officially expires in March 2026. The reason wasn't about science, it was about procedural discipline. The court ruled that Dr. Reddys failed to clear the way by legally challenging the patent through revocation proceedings before they started manufacturing and exporting the drug. This ruling marks a fundamental shift where procedural malafide now carries as much weight as the actual validity of a patent. By punishing makers, players for jumping the gun, the court has prioritized legal etiquette over immediate public access to an essential medicine. Critics argue this sets a dangerous precedent that could scuttle access to affordable drugs, even when patents are legally questionable, as maybe in this case. In a world of rising healthcare costs, it's essential to think now, can we really afford to let procedural technicalities keep likely invalid patents alive? And that's all. Back to Penish.
Thanks a lot, Kartikeya. And now we'll discuss the top developments based on the jurisprudential rigor in them. And to discuss the first development under this, we have Sonisha.
Thank you, Praharsh. So the decision that I'm going to be talking about is Hoffmann-La Roche versus Natco Pharma. So basically, this dealt with the tension between patent protection and public interest in access to life-saving orphan drugs. So basically, this was a dispute between Roche and Natco over risdiplam used for treating spinal muscular atrophy. And the court basically used anticipation and obviousness as two ways to go about with it in discussing genus species patents. So, on anticipation, the court held that a compound may be anticipated if it's discernible to a person skilled in the art from a prior genus patent. And with respect to obviousness, the court employed a stricter test of person in the know test of asking the question of whether the inventor of the genus patent already knew of the species invention when filing the patent for the first time. So now this is a very rarely used doctrine, and it's jurisprudentially rigorous because it addresses the information asymmetry with respect to genus species disputes. And it's also a very well written judgment because the court took into account different factors before passing the interim injunction. And also, this case addresses some of the critical ambiguities which were left unresolved in the Novartis versus Union of India. So, in our SpicyIP blog, we have Dr. Victor Vaibhav as well as Praharsh and Bharatwaj, who have very nicely put up blog posts explaining the decision of the court in this case. I highly recommend everybody to give all of that a read.
Thanks, Sonisha. So the second development that we have in this category is the revocation order which was passed by the Indian Patent Office pertaining to Novartis Entresto patent. Now this revocation comes after a long list of orders, decisions by both Indian courts, Delhi High Court, a single judge and then a DB, and also by the Indian Patent Office, where the Patent Office had rejected the application to grant a patent and then eventually granted it, and then the matter went to the post-grant opposition, and then finally this order came out. So for those who are interested in knowing more about how litigation and prosecution works hand in hand, I would suggest check out different blog posts on this by Yogesh, me, and other folks. Now this particular order is very interesting because of three reasons. It's an order which is passed by Indian Patent Office, and it clearly shows that apart from applying law and apart from looking at the technicalities or the science behind the invention, the patent office also has to take into account all the developments which are taking place on the side, which includes not only the evidence that has been given by the parties, but also the stances taken by the parties in different litigations prior to this hearing. That is what happened in this case, where the IPO said in an interim injunction application pertaining to a different patent, Novartis had taken a stance that within that suit patent, the crystalline supramolecular complex of sacubitril and valsartan were covered, which is exactly what was patented in this case. Now, the IPO said that you cannot take a stance earlier and then say that, oh no, that patent did not concern with this particular invention. Similarly, another important aspect of this order is its detailed analysis of Section 3D. We saw Section 3D in action, which asked for a need of enhancement of known efficacy. And the third and most important aspect of this order was that it clearly shows that post grant oppositions are not there to delay granting of patents or just to waste time of the innovators, they actually serve a very important purpose. So with that, we'll move on to the next development, and for that we have Malopika.
Thank you, Prahash. Now, let's move on to a different question. How far can the foreign courts reach into India to collect evidence in patent disputes? So for this, we will look into this very interesting case known as the Softgel Healthcare Private Limited versus Pfizer Incorporation and others, a Madras High Court decision. This was an important procedural decision. The Madras High Court has refused to execute the letters rogatory issued by the United States Court in a patent dispute involving Pfizer and an Indian manufacturer, that is Softgel Healthcare. So first, a quick explanation. Letters rogatory are basically a formal request from one court to another asking for help in collection of evidence, like document or witness testimony. These requests are often rooted through an international convention, that is the Hague Evidence Convention 1970, which basically sets a rule for cross-border judicial assistance. Here, Pfizer was litigating in the United States District Court in Delaware over its patent relating to tafamidis, sold as Vindamax. The US court, interestingly, issued a letters rogatory asking the Indian courts to collect documents and testimony from Softgel, which here they manufacture the drug for the third parties. Now, what happened in India? A single judge of the Madras High Court had earlier allowed the request and even set up a confidentiality club. But on appeal, the division bench set that aside and refused to enforce the letters rogatory. The court gave three reasons: that India has exercised reservation under Article 23 of the Hague Evidence Convention, and that means that India will not execute any requests that look like a broad pretrial discovery. But this broad pretrial discovery is something very common in the United States. Second, the court found a request was too broad and vague. This did not meet the requirement of specificity under the convention, that is a Hague Evidence Convention. Third, Softgel was interestingly not party to the litigation that was happening in the United States District Court, Delaware. The court said that here forcing a third party to hand over sensitive material could affect confidentiality and even India's sovereignty and domestic legal interest. The result was this: the appeals were allowed, the earlier order was set aside, and Pfizer's request for commission and evidence collection in India was dismissed. Now we move on to the next segment.
Thanks a lot, Malopika. So with the last development in this category, we'll be talking about a decision passed by the Delhi High Court in Roche versus Zydus Lifesciences, and it pertains to pertuzumab. This judgment is important because it applies or it interprets Patents Act on biologics patent disputes. Now, Section 104A provides that in process patent infringement cases, the burden shifts to the defendant to prove that they have used a different process. But this burden will only shift when the patentee establishes that the defendant product is identical to that of the patentee's product obtained through a patented process. By very nature, biologics cannot be, they cannot be replicated, so to speak. So this was the argument which was taken by Roche that, we won't be able to fulfill this requirement that is there under Section 104A because our product is a biologic. And therefore, the burden automatically shifts to Zydus to prove that, they have used a different process. Now, the court clearly said that, listen, Section 104A does not really distinguish between biologics and non-biologics. It is going to apply in a similar fashion on both these kind of products. So what the court basically did here was that it refused to take a very narrow understanding of this important safeguard that is there within the Patents Act, and then it backed it up by some solid reasoning. And folks who are interested to know more about this, take a look at Subha Lakshmi Mukherjee's blog post on this. With that, we'll be moving on to important policy related developments that took place in India. And for this, we have Kartikeya to discuss the first development.
Thank you, Prors. So India is finally building a high-tech shield around its ancient medicinal soul to prevent global biopiracy. The Indian Patent Office recently issued new draft guidelines specifically for AYUSH systems, which include Ayurveda, yoga, and homeopathy. For years, the world has looked at traditional knowledge with massive interest, but these guidelines ensure that only genuine, non-obvious innovations and not just simple mixtures of known herbs receive patent protection. A critical new hurdle is the requirement for scientific data proving a synergistic effect, which we are already aware of in the Patents Act. This means you must show through experimental results that a combination of traditional ingredients works significantly better than the ingredients would have on their own. Furthermore, any invention using Indian biological resources must strictly disclose its origin and seek approval from the National Biodiversity Authority. This is a sophisticated attempt to align sovereign heritage with modern IP standard. By demanding hard data for synergy, India is forcing the AYUSH industry to move from family secrets to validated scientific truths at this point. It protects traditional practitioners from unfair monopolies while inviting global research, but strictly on India's terms. It's a bold move to ensure our medicinal history fuels modern progress without being exploited. As we blend ancient wisdom with modern law, are we finally reclaiming the rights to our own heritage? Something to think about. Back to you, Praharsh.
Thanks a lot, Kartikeya. We'll have Bharatwaj now to discuss the next three developments under this category.
So yes, so I will be focusing on three developments. The first development, which is the performance evaluation system for examiners and controllers, is a step up because the previous office order, which was governing performance metrics, could be classified as an outcome-based measurement system, wherein the examiners and the controllers are to produce certain outputs. These outputs would include orders, FER reports, notices, and all that stuff. And for every month or for every measurement period, they are required to produce, let's just say, 20 or 30 FERs or 30 orders, so on and so forth. But the new office order is shifting, wherein what they are saying is, no, we are not going to look at the outcome, but what we are going to do is that the entire workflow of the patent examiner and the controller would be broken down into tasks, and each task would be assigned a points, and every examiner and controller is required to obtain around 100 points. And if he attains more, then he's doing well. If he's scoring less than 100, his performance has to be evaluated. To put it short, I think this is a very important development to the extent that it is a more accurate map of the workflow relative to what was previously existing. And secondly, it also forms the background condition under which the Indian Patent Office issues orders also, right? SpicyIP has covered how the Patent Office has been dragged by the courts for issuing unreasoned orders. And these performance metrics form a background conditions, right? And in that sense, because of the fact that it is a more accurate representation of the job of an examiner or a controller, it kind of enables the examiners and the controller to do their jobs properly and hopefully reduce also unreasoned order. So from that perspective, it's an improvement. Secondly, the second development is with regards to the CRI guidelines 2020. So the CRI guidelines, there have been multiple guidelines that have been issued over the years. Swaraj has a very nice post on the ping-pong paradigm of computer-related inventions. In this, what had happened is the stated goal has always been the same with regards to most of these guidelines, which is to create consistency in application of Section 3K to what the Patent Office calls the computer-related inventions, right? Along with Swaraj and Yogesh, myself, we had submitted comments to the CRI guidelines 2025 and also had the opportunity to present our views before the Indian Patent Office. To put it simply, the problem is that it suffers from a syndrome wherein the basement is very weak, but the building looks very strong. So the guidelines looks awesome because they borrow from judicial precedents and everything and that. But then the basement, the judicial precedents are confusing to say the least, right? And we had at SpicyIP, I and Yogesh, we have written extensively on the fact as to how the jurisprudence has been fragmented, it's confusing. And in a more recent post, I had also discussed how the courts have, in a sense, used the word technical too much to the extent that it has no meaning. And it has simply led to reducing Section 3K to a mere formality. So with all that context, to be honest, the guidelines, even though it is the Patent Office is responding to what the courts are doing, which is good, because or else if they are not responding, then they will again be dragged by the courts. But also, to what extent it would be effective is a big question. So now moving on to the third development, which is the CDSCO has issued a public notice recently, wherein they have invited comments on creating a level playing field with regards to drug regulation. The argument is this, like you can consider there are two entities, which is the first mover, the one who would be, let's just take a new compound, chemical or biological compound, and for that compound, certain data has to be generated, regulatory data has to be generated to ensure the safety and efficacy of the drug. And for that process, there are detailed guidelines, the new clinical trial rules 2019. As per that, they will have to generate certain level of regulatory data to show that the drug is safe and efficacious. Now, as in India, as it stands, we have a data secrecy regime, not a data exclusivity regime. So what it means is that any follow-on company can rely on that regulatory data that has already been submitted by the first mover and then get their own copycat drug approved. Now, this has been seen by the CDSCO as being problematic. They are saying that it is not creating a level playing field for the first mover, and he has to spend so much money generating all this regulatory data, and the follow-on simply come and free ride, which is, at least from their point of view, seems to be very problematic. That's what they perceive to be. And to that effect, they had issued a notice. Now, the problem is that any form of data exclusivity or any form of regime granting exclusionary rights automatically has access costs. Sabi had written a very nice post marshalling some empirical evidence showing how any form of data exclusivity introduced in other developing countries had, let's just say, access costs, which means that they have increased the cost of medicines for lay consumers even after the patent has expired. But from what I checked today, the CDSCO there has not been any new notice on this, and we do not know what will happen. But stay tuned if any development will be posted in SpicyIP.
Thanks a lot, Bharatwaj, for nicely summing up these three important developments. Now we have Ambika, who will be talking about the next development under this category.
Thanks, Prash. So there has been a new amendment in the patent rules. The Jan Vishwas Act, which was passed in 2023, had the goal of decriminalizing minor offenses and also just generating a more sensible ease of doing business within the country. And this also had an impact on the Patent Act in itself. Specifically, Chapter 14A, which calls the new chapter, according to the amendment, calls for a streamlined process of civil adjudication of penalties and appeals. And basically, this new chapter contains details of a digitalized and time-bound procedure. This will be very useful in due diligence mechanisms in patent enforcement cases. But as much as the end-to-end digitalized procedure has been appreciated in the news cycle, Karthik on the SpicyIP blog discusses some great points. For example, the fact that we need more clarity on who these adjudicating officers will be and what is the exact extent of their powers. So while this is a good move we can look forward to, unfortunately, it may not offer as much legal clarity as we were expecting from it.
Thanks a lot, Ambika, for nicely summing it up. And to discuss the last development under this category, we have Karthik.
Thank you, Birch. So, over the past 60 years, nuclear energy in India was a government keep out zone. But a radical new law has ended that state monopoly forever. The Shanti Act, or the Sustainable Harnessing and Advancement of Nuclear Energy for Transforming India Act of 25, has completely overhauled India's nuclear landscape by repealing the restrictive 1962 Atomic Energy Act. The most shocking change is the amendment section 4 of the Patent Act, which previously strictly prohibited patents for anything related to atomic energy. Now, for the first time, India will grant patents for inventions related to the peaceful use of nuclear energy and radiation. While strategic activities like uranium enrichment stay under government control, the race for peaceful tech like small modular reactors is now open to private companies and joint ventures. But this is a true innovation reset, designed to meet India's ambitious 2070 net zero goals. By allowing private patents, the government is basically admitting it needs the agility and capital of the private sector to power a technologically advanced India. However, the law has triggered intense criticism because it removes supplier accountability for accidents to attract global vendors. India is transforming from a nuclear recluse into a dynamic clean energy hub, but the lack of liability remains a major point of contention. It's important to think, is the promise of clean around the clock power worth the sacrifice of holding equipment makers accountable for safety? That's all. Back to you, Prash.
Thank you. Thank you so much, Kartikeya. And now we'll be moving to the fourth category, which is other IP developments, which are not falling under the first three categories. And to discuss the first development under this, we have Ambika.
Thanks, Prahash. So the last couple of years, we have seen that the divide between patent law and competition law in India is getting deeper and deeper, and especially because of a lot of back and forth between the courts about where jurisdiction for CCI begins and where jurisdiction for patent should end. In July 2023, the Delhi High Court was discussing 4 appeals and 1 writ petition combined in the case of Ericsson versus CCI. The division bench here held that the Controller General supersedes the powers of the Competition Commission, and the Patents Act will override the provisions of the Competition Act. This then went to the Supreme Court, but the Supreme Court unfortunately did not engage in the issue. At the same time, a parallel case of Swapande versus CCI was also going on the same issue. From this case, we again have an appeal to the Supreme Court. So now the Supreme Court has a second chance to decide whether scrutinizing antitrust claims is a power of the CCI, as it should be, we think, or the Controller General. The only remedy who can offer is a compulsory license, which in our view does not match with the needs of a healthy patent regime. So we look forward to what the Supreme Court will decide. Until then, unfortunately, India is the only jurisdiction where the Competition Commission does not exercise any control over patent disputes. Especially troubling is the fact that the Supreme Court had previously decided a more harmonious construction among the powers of the CCI and the coal controller and the telecom regulatory. So why not also have the same kind of exercise for the Competition Commission again? Stay tuned to our blog. We will definitely be covering up whatever happens at the Supreme Court next. Back to you, Prahash.
Thanks a lot, Ambika. So in Inkite Holdings versus Granules India Limited, the Delhi High Court recorded a settlement between these two parties on a patent dispute concerning ruxolitinib, I hope I'm pronouncing it right, which is a drug which is used to manage myelofibrosis, a rare bone marrow disorder. The settlement was recorded after Granules, the defendant, said that activities manufacturing or listing the infringing products on Pharma Compass website is not actually for commercial purposes, and it's actually done to get necessary regulatory approval, which are then covered under the Bowler type research exemption permitted under Section 107A of Indian Patents Act. Now, the courts recorded the settlement, but it eventually left us with a bigger question that, considering the situation that the parties found themselves in, wouldn't it have been better if these parties would have resorted to pre-institution mediation and sort this thing out between themselves instead of filing a case and then, going ahead and litigating it? Something to think about. To know more about Bowler exemption, I would highly recommend Professor Bashir's post on that. And also, for this particular development, they can check out Tejaswini's post on this. With that, we have Malobika, who will be talking about the next 2 developments under this category.
Thank you so much, Prahash. Now, bringing your attention to a very interesting development, that is an SCP dispute and what its culmination had been. So in a recent development, Philips NV and Vivo Mobile Communications Company Limited have settled their long-running standard essential patent dispute, SCP dispute, that it is relating to 3G and 4G technology. The settlement was confirmed before Justice Amit Bansal of the Delhi High Court, bringing an end to a litigation that has been pending for near about 5 years. So thinking about the litigation and how it started back in 2020. Philips had filed a patent infringement suit against Vivo before the Delhi High Court. Now, Philips alleged that Vivo had used 5 of its standard essential patents without obtaining a license. To support its claim, Philips produced several Vivo smartphones, including V17 Pro, V15 Pro, as sample devices. Now, Vivo's defense, on the other hand, followed a familiar pattern in SCP dispute. What was this? First, Vivo challenged the essentiality of the patent. Second, it argued that the licensing terms offered by Philips were not in FRAN terms, that is fair, reasonable, and non-discriminatory. They were not FRAN compliant. Vivo also claimed that the relevant technology was embedded in the chipset, that is the chipset, which they had already purchased from Qualcomm. So the case progressed in the usual manner. As I said, it was progressing for 5 years. Issued were framed. Delhi High Court also, interestingly, constituted a confidentiality club. However, in April 2025, the parties submitted a joint application stating that they had entered into a licensing agreement. The terms of the settlement was not made public, but the court reviewed it. So the court then disposed of the main suit. As a part of the settlement, the phones produced before the court was returned, confidentially records were destroyed, and the restrictions on Vivo's properties were lifted. Such outcome can tell us that today most SEP disputes end in negotiated settlements rather than final judgments. Interestingly, following this settlement, Vivo reportedly had no other pending SEP litigation. This development thus also raised a question whether the firm approach of the Delhi High Court in cases like Lava versus Ericsson had this encouraged the settlement of dispute outside the courtroom. You can check out this blog by Sushant Jaiswal. He has covered this in his SpicyIP blog. Please check it out. So now, finally, the timing of the settlement appeared favorable as Vivo reportedly emerged as a top-selling smartphone brand in India in the late 2024. Let us now shift our focus from litigation to institutional reforms within the intellectual property system itself. In the annual report of the Office of Controller General of the Patent, Design and Trademark, that is CGPTDM for 2024 and 25, a significant development was observed. What is this? To address a long-standing substantive backlog, the Patent Office carried out a major internal reorganization that is promoting around 370 patent examiners to controllers. This, the annual report reports, that led to a record disposal of 1.26 lakh patent application in the financial year 2023-24. But this internal reforms also led to some problems and created some shortcomings. What were these? It created a legal hurdle in the recruitment of new examiners. This was delayed. This delay in turn kind of increased the pendency at the first examination report for patents. A similar issue arose in the trademark registry, where discontinuation of contract examiners resulted in a reduced examination output.
Yeah.
So in January 2025, the Patent Office inducted around 407 new patent examiners. These examiners underwent a 16-week structured induction program known as the Bodhik Agman. Apart from this, there were a lot of developmental patent exam training programs that was carried out between the National Institute of Industrial Property of France, the Eurasian Patent Organization, Taiwan, Kyrgyz Patent Office. Now, more or less, what we have seen that the government developing on this sanctioned 200 new posts in the trademark registry, including 120 examiners and senior examiner position to strengthen the examination capacity. Thank you.
Great, thanks a lot. With this, we wrap up the discussion on important IP developments in patent landscape, and we'll be discussing the important copyright developments in our next episode. Thank you.